Editorial: a kindergarten child in Phnom Penh asks, if Mr. Anutin can draw a map unilaterally, why stop there? Why not draw the entire world as Thailand? Anutin has rejected the maps prepared by the Franco-Siamese Boundary Delimitation Commission under the 1904 Convention and the 1907 Treaty, insisting instead that Thailand should rely solely on maps at the 150,000 scale. Such a position is not merely a political opinion. It touches upon fundamental principles of international law, which form the basis for the demarcation and recognition of boundaries between sovereign states. In fact, the maps produced through the boundary delimitation process under the 1904 Convention and the 1907 Treaty were not documents unilaterally drawn by either party. They were the result of an internationally agreed process, recognized by the parties concerned, and officially published in 50 copies for transmission to the Siamese government. The receipt of these maps by the Siamese Embassy in Paris in August 1908 constitutes historical evidence of acceptance and the absence of objection at that time. International law recognizes an important principle known as acquiescence. This principle holds that when a state has accepted or failed to object to a document or arrangement over a prolonged period, it cannot later repudiate that same document merely for political convenience. For this reason, the International Court of Justice, ICJ, places considerable weight on the conduct of states in the past, rather than relying solely on contemporary political assertions. Some have posed the question, if Thailand can rely on a map that it has drawn unilaterally, why should Cambodia not rely on maps of the Khmer Empire? This is a rhetorical challenge designed to expose the illogical nature of unilateral cartographic claims. If every state were free to draw maps according to its own wishes and proclaim them as official boundaries, the entire framework of international law would lose its meaning. Borders between nations would no longer be determined by treaties and agreements, but by the political desires of whoever happened to be in power at a given moment. In this context, a humorous yet thought-provoking question was reportedly raised by kindergarten children in Phnom Penh. Open quote, if Uncle Anutin can draw maps unilaterally, why stop at taking just that piece of Cambodian land? Why not simply draw the whole world as part of Thailand? Ah! Close quote. While humorous on the surface, the question reflects a simple but profound logic. Territorial claims cannot be based merely on lines drawn according to the wishes of one party. Otherwise, international law, treaties, and the collective recognition of the international community would become meaningless. Cambodia, however, has not chosen such a path. Instead, it has consistently adhered to the principles of international law, particularly the respect for treaties and duly ratified documents. This marks a clear distinction between claims rooted in legal principles and those driven primarily by nationalist sentiment. The observations made by Professor Emeritus Dr. Surachart Bamrungsuk further reinforce this point. He noted that in boundary disputes between states, the legally relevant instruments are treaties and the maps attached to them that have been formally ratified. Maps produced later, or maps lacking a treaty basis, cannot serve as valid legal evidence for altering boundaries that have already been internationally recognized. The significance of Professor Surachart's analysis lies in the fact that it does not originate from the Cambodian side. Rather, it represents a cautionary message from a respected Thai political scientist directed toward his own country's leadership. He linked the issue to the 1962 ICJ judgment in the Temple of Priya Vihar case, in which the court gave primary consideration to the boundary delimitation maps. By contrast, maps produced independently by Thai experts were regarded as carrying far less legal weight than maps generated through the official delimitation process. History offers a clear lesson. When a dispute reaches an international court, the outcome is not determined by political speeches, nationalist emotions, or newly drawn maps created by one side. What matters are legally valid documents, duly concluded agreements, and the conduct of states demonstrating acceptance over time. Therefore, insisting on the exclusive use of a 150,000 scale map without regard to its legal status reflects a political argument more than a legal one. By contrast, reliance on treaties and duly ratified maps is consistent with international legal principles and is more likely to withstand scrutiny in any international legal forum. Ultimately, boundary disputes are not competitions to determine who can draw the largest map. They concern the rule of law, sovereignty, and respect for international obligations. History has repeatedly demonstrated that success before international tribunals does not belong to those who shout the loudest, but to those whose legal foundations are the strongest. This is the essence of the rhetorical challenge posed above. It highlights the distinction between claims based on emotion and claims grounded in law. And perhaps, in the innocent question of a kindergarten child, there lies a reminder of a fundamental truth. If borders could be changed simply by drawing new maps, then the entire international legal order would cease to exist.